and this is why we're here. I could make you write a 500-page apology note to me if you don't accept this. And that's when I just
that is
shut up and listen.
Not true, and I can play the video.
Gentlemen. Welcome back to the vault. Today, we are diving into a case that starts with a simple traffic ticket but spirals into a heated battle over police authority and integrity. We're in Royal Oak, Michigan, where Joseph Nitsky isn't just fighting a no left turn citation. He's accusing the officer of high-level bullying and an unhinged 500-page demand. Is this a case of a driver caught in a speed trap or an officer being unfairly slandered? The tension in this room is about to boil over as bodycam evidence becomes the only way to find the truth. Buckle up, because this minor hearing is about to get incredibly personal. And that's when I just shut up and listen. Officer Hadrinos did in fact issue the citation on the date in question.
Point non-moving violation. The record should also reflect that there has already been a $175 bond posted. So the court's going to explain the procedure.
Let's pause here to look at the legal strategy used by the officer.
This is an informal hearing.
Initially, Nitsky was pulled over for a prohibited left turn, which is a 2-point violation that affects your insurance and driving record. However, the officer used his discretion to cite him for impending traffic instead. This is a 0-point non-moving violation, essentially a paperwork ticket that carries a fine but no long-term damage to a driver's record. Usually, this is seen as a major favor to the driver, and as we're about to see, Mr. Nitsky isn't feeling particularly grateful for the break. It is said you were operating a 2013 Buick. I want to deny.
Hadrinos' note, which appears on your ticket, indicates eastbound 13 mile made prohibited turn at Campbell, posted no left turn due to the construction, which was fairly infamous at that period of time. So what the officer did do, Mr. Novitsky, is on the roadway, rather than issuing a citation for disobeyed traffic control device, which is a 2-point violation, he chose within his discretion as permitted to him by command staff at the Royal Oak Police Department to issue the 0-point non-moving violation of impeding traffic. Notwithstanding any of that, today's your day in court. So you do have 3 options to protect your rights. You may admit responsibility in this matter. The court would simply hang on to the $175 bond posted, and that would close the case. You may admit responsibility with an explanation that you believe further mitigates your circumstances. Your third option is to deny responsibility. That is your right and your privilege. If you do so, the court would swear both parties under oath. The officer would testify first. They have the burden of proof today. Then it would be your turn to testify. Tell the court what you wish the court to know, and then the court would make a finding of responsible or not responsible. But please understand, because we are in civil court and not in criminal court, the burden of proof is a mere preponderance of the evidence, otherwise known as the featherweight test. So, as to impeding traffic in some form or fashion, do you wish to admit and explain, or deny responsibility?
I want to deny.
Very well. Please raise your right hands, gentlemen. You solemnly swear the testimony you shall give before this court shall be the truth.
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. The officer has the burden of proof. Mr. Novitsky, then it'll be your turn. Officer Hadrinos.
Your Honor, on the date in question, September 8th, 2025, approximately 10:12 in the morning, I was parked on Windermere, which is one street north of 13 mile off of Campbell. So I was on the west side observing traffic for this intersection because there was a construction on 13 mile. It was posted very clearly.
Now we're getting into the he said, she said of the actual incident. Officer Hadrinos claims he was strategically positioned to watch this specific intersection due to construction. The core of the prosecution's case is simple. The sign was there, it was visible, and the turn was made. Notice how the officer emphasizes that he was polite and gave him a break. He's setting a narrative of professional leniency, which makes the upcoming allegations from the defendant even more shocking. Do you think an officer would offer a point reduction if they were actually trying to bully someone? Stopped him on Marge Street. It was 4 lanes left.
At the scene with impeding traffic. However, at this point, it should be amended back to the prohibited turn now.
The court can consider any motions relative to this matter after receiving the testimony from both parties. And is there anything further, Officer Hadrinos, you wish the court to know?
No, Your Honor.
All right. You obviously have the right to rebuttal if you choose to use it. And we turn to Mr. Nowitzki. Mr. Nowitzki, what would you like to tell the court?
Good story. I was proceeding eastbound on 13 Mile. It's 5 lanes. It was reduced to 2. 3 lanes in the middle were being resurfaced. And so the sign that the officer suggested was posted 5 lanes north. He was out of the cone of vision. I sent you some photographs of this.
You can hear the frustration in Mr. Nitsky's voice. He isn't just arguing the law. He's arguing the physics of the scene, claiming the sign was outside his cone of vision. He's using very specific language, prudent, cautious, cone of vision, to paint himself as a highly responsible driver. But here's the drama. He's essentially calling the intersection a speed trap and accusing the police of entrapment. This is a bold move in front of a judge. Would you be this animated if you were just fighting a 0-point ticket, or does this feel like someone defending their honor? The court just simply wants this matter to remain, and he described as what he thought it was a break.
Were mailed to the court plus or minus September 16th of 2025. So you may continue, Mr. Nowitzki. Please continue.
Thank you. I took a very prudent turn, not imprudent. It was very slow and cautious. There was no cars coming westbound, 0 cars coming westbound. There was 0 cars in back of me for at least a half a mile. It was very, very light traffic. There was 1 car parked in the intersection with his left turn signal on, going southbound on Campbell, without any postings, without any lights indicating no left turn. I assumed that taking the same left turn in the same intersection with 3 lanes being available to park for traffic to clear was a prudent decision. Your Honor, it was not in clear, visible lanes. Now, here's why we're here. When we got to Millard, I did, in fact, say exactly what I just said. That was a very prudent turn. It wasn't visibly posted. I felt it was a speed trap. I saw the Royal Oak officer parked in Madison Heights, I believe, not Royal Oak. And so I asked him, is this normal? Is this all? It didn't feel normal. It felt like entrapment, if I may use a word without being a lawyer. And he said, Mr. Nowitzki, I'm going to cut you a break. And he described what he thought it was a break. And I said, wait a second. You're making this whole thing up. Wait a minute. This whole thing is being fabricated here for God knows what reasons. I don't know. I said, look at my record. I'm a very prudent driver. I don't. And he said, listen, if you don't calm down here.
And there it is, the bombshell. Nitsky claims the officer threatened him with a 500-page written apology, or else. This is a massive accusation. If true, it's a gross abuse of authority. If false, it's a desperate attempt to discredit the officer. Look at the officer's immediate reaction. He's practically jumping out of his seat to rebut. In legal commentary, we call this a credibility contest. Without bodycam footage, the judge has to decide who is more believable, the officer with the clean record or the animated driver who feels victimized. Gentlemen, thank you.
Even though it's an informal hearing, we have to follow the rules of procedure as closely as we can so that we have a clear record in case this matter somehow finds itself before the chief judge on some form of an appeal. So, Mr. Nowitzki, if you can continue.
Well,
that's
anything else? All I can tell you is that we're here because of the 500-page demand. I loathe bullying, Your Honor. We're living in a very strange moment in time where it seems to become more and more acceptable. I refuse to accept it. We're here because of that exact statement, Your Honor. In good faith, I already gave you the check. It's not about the money. It's about making it up and then threatening me with authority that I don't perceive an officer has. And that's why we're here. And if we have to go to another court and get an attorney to represent this, because I'm telling you the gospel here, Your Honor, If I have to go someplace else, I will. I refuse to sit back and let this guy bully me or anybody else. And if that's what we have to do here, let's do it. I'm not afraid to go anywhere else. I'm not afraid to hire an attorney. I refuse to be bullied for something that I didn't do. Thank you.
Thank you. Rebuttal testimony, Officer Hadrinos.
Well, I'm trying to bring up the Axon video, but I just got locked out of my account. But that's an absolute lie. That's not anything that I use. I don't say anything like that. Mr. Visky is absolutely lying. If I could bring up the video, I would show you. Can you look at evidence.com, Your Honor, there, or do I have to bring it up and share it?
Honestly, in
Because I'll bring up the
3.5
body
years,
cam because
I
that
have
is an
not done that.
absolute lie.
If that's going to take you a minute, which is fine, here's what the court can do. We can just take a brief adjournment. If it's just going to take you a minute or two to get back into that, that's fine with the court, because the court wants each party to have ample opportunity to make their statements to the court in full. So why don't we just break for...
This is a total nightmare for the prosecution. The officer wants to prove the defendant is lying, but he's locked out of his evidence account. In modern courtroom drama, the digital reveal is the ultimate climax. But here, we're met with a technical glitch. Notice the shift in energy. The officer is frustrated because he knows the video is his vindication. Meanwhile, the judge is trying to maintain order in an informal hearing that has turned into a high-stakes character assassination. If you were the judge, would you trust the officer's word without seeing that video?
You already indicated that you believe Mr. Nowitzki was not being truthful with respect to the remark about something about a 500-page apology letter.
Well, that's
this
one.
is your...
That's one. The first one was that it wasn't clearly marked. I don't know when his pictures were taken, but I when I sit on those intersections, I make it a point to drive the way that the signs show so that I can view and make sure that they are properly marked. And that was properly marked so that I could sit there and write an appropriate ticket. And then secondly, yes, that is a bold-faced lie that I told him he could write a 500-page essay or word essay or whatever apologizing to me. That is not anything that I would ever say.
All right.
And I'm sure the video will show.
Thank you. So that the record is as plain as it can be, what the court intends to do right now, and the court hopes you can see, is
I'd like
this
an
is actually
adjournment then.
this is actually Mr. Nowitzki's exhibit, and if
There's
that
the sign.
right, okay. So can you describe for the court what you're seeing and whether that comports with what you saw in person that day, Officer Hadrinos?
Well, I can't specifically say that that's exactly what I saw that day, but that sign is at the end of the intersection, right at where you would see it as you're driving. And then if you look, the left-hand turn signal is also blocked out with black covering.
So what the court wants the record to reflect, if it is so, is that this is the view eastbound on 13 Mile Road at Campbell, as you recall it, with the same physical features and barricades. Is that correct?
Yes, I can't speak for exact placement on a left turn sign, but it's still, that picture still clearly shows that, yes, at that intersection, you cannot make a left turn.
Okay. And is there any further rebuttal testimony?
Well, I'd rather you adjourn this now and bring it to another date so that I can show the video of, because
Okay.
I'm not going to let stand his accusations that I bullied him. I obviously was very cordial with him because I gave him a break. If that was the case, if I was bullying him, I wouldn't have given him a break. I would have given him the full citation.
What the court is going to do at this time is grant a motion to adjourn without adjudication. So the court is not making a ruling at this time. The bond remains in the court's escrow fund, and the court will indicate motion to adjourn without adjudication. The court can't tell you two gentlemen whether or not it'll be in front of Judge Kowalkowski or Judge Meineke, but at that point, obviously,
What started as a simple 175 traffic ticket turned into a battle of integrity. We saw a defendant who felt bullied by authority and an officer who felt slandered by a bold-faced lie. Ultimately, the judge made a tactical decision, an adjournment without adjudication. This means no ruling today. The case is being moved to a formal hearing where the city attorney will get involved and, most importantly, that bodycam footage will finally be played. It's a cliffhanger for Joseph Nitsky, as his day in court isn't over just yet. This case reminds us that in the courtroom, your attitude and your evidence are everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments. Was the officer bullying or was the driver overreacting? And don't forget to subscribe for more jaw-dropping courtroom breakdowns here on Trial Territory.